So as Danielle said, I have a dual role in my life. So I'm a scientist, and right now I'm the biosafety officer at the Instituto Gulbenkian de Ciência. But some years ago, in 2016, I also decided to take a law degree to understand a little bit better the legislation that I was dealing with. And right now I'm also working as a lawyer in a law society. And in this, I've been working mainly in health law and pharmaceutical law. And I was asked to give you a very brief overview about personal data, what is data treatment, what are the major principles that we have to be aware. And then in regard to health data, we have the informed consent, the retention of the health data throughout our clinical studies or the clinical file that we have in hospitals, how this applies to the clinical studies and trials. We also have the problem of the biobanks and, as I said, the clinical data. So the slides have a sum up of the things that I will be talking about. It's full of text, but I'm going to simplify it a little bit. In terms of personal data, it's only considered to be personal data when you can identify a person, okay? And this identification might occur through directly through the name and the address or the phone number of a specific person, or might occur indirectly. And this is where it comes the pseudonymization. So we transform this into a code, but this code is present so we can still identify a person. Also, we can have a situation where we have an indirect identification of a person by a very specific trait of that person that is applicable only to that person. So in this case, you need also to be careful, because even though you might not have for instance, the name of that person, because that person is the only person with that trait, you are able to identify such person. Then you have two types of sensitive data in relation to personal data, which is the data concerning health, and that is the data that you are going to do, including the provision for healthcare services or the health status of a person, the diseases that this person might have had. And you also have the data concerning genetic data, the characteristics of the inherent characteristics of this person. This type of data is even more protected, let's say like this, than the rest of the personal data of that person. It is not considered personal data, the data that you obtain that is already anonymized. So if I cannot in any possible way trace back some data to a person, this data is anonymous and it's not considered to be personal data, so it falls out of the scope of the GDPR, which is the General Data Protection Regulation. Now, you also need to be careful that processing doesn't only mean that I've collected the data and then I'm going to do something to this data. The actual procedure of collecting the data is already included in the processing definition. So if you are collecting some data that at the time of collection, it's not anonymous, it falls down the data protection regulation, because this collection procedure is still inside the provision of the regulation. And then all these principles of data protection will apply to the operation of getting the personal data. Now, you also have to be aware that this applies to all citizens of the European Union, independent of the place where this person is living. So if I'm treating a personal data of a person that lives in the US, but that person is a citizen of the European Union, the GDPR is included, okay? The GDPR, the treatment and processing and personal data does not include, one, deceased subjects. So if the person is dead, it doesn't fall under the data protection regulation, but nevertheless be careful because there are other provisions in different legal diplomas that protect the integrity and the memory of the deceased subjects, and those need to be respected. Another thing that is not considered personal data is the data related to legal persons, basically companies. Okay, so the treatment of data related to different companies doesn't fall on the data protection regulation. And again, if you anonymize the data, it doesn't fall down the data treatment. It's not a data. It's not included in the GDPR, but pseudo-anonymization is. And in this, you need to be very careful because if someone has the key, the very existence of the key makes this unidentified data. It doesn't mean that you yourself have to have the key, but if another person has the key exists, so the data is not anonymous anymore, okay? Now, two very important principles that I think people need really to take into account when they are thinking about data protection, which is the data protection by default and the data protection by design. Meaning, when you are thinking about the data that you need to collect, even before you collect the data, you need to think if you need all this data that is being collected. We are very, very used to fill in forms that asks for our name, address, age, civil identification number, taxpayer number, whatever. But you need to think that for your specific purpose, is all this data that you are going to collect necessary? Which is the data protection by default. By default, you are only allowed to collect the data that is to the extent that is necessary. By design, you have to take into account the technologies that we have at our disposal nowadays to check if with all these technologies you are still able to identify this data, and if this data needs to be identified or not. Can I do my work with anonymous data? And there is a lot of situations that if you think it through, you don't really need to identify the people that gave the data, so the data could be anonymous. Also, the data needs to be collected for specified, explicit, and legitimate purpose. So you cannot collect data for everything. You need to say for what are you collecting data, and you need to say to say for each of the processes that you are collecting this data. And it cannot be, I'm going to go in a while again to this, but it cannot be a general thing that's saying that I'm going to collect data for this and for all the future things that I will need. Now, we also talked about this today, and I already referred this, that it is, by principle, it's forbidden to collect data that relates to genetic data or data concerning health. This is the general principle. Then you have the exceptions to this principle. And since the general principle is a prohibition, in here you have to justify much more why are you collecting this data? Because you are forbidden to do so. And it's not only because one of the exceptions is that the data subject gave you explicit consent to treat this data, that this might solve everything. Because once again, you have privacy by default and privacy by design. You need really to justify it, even if the data subject gave you explicit consent. Why do you need this data? Now, there are also two other legal justifications. So for medical diagnosis or for the provision of healthcare, the treatment of this data might be already justified. So you might not need the data subject to give you the explicit consent. And another reason that makes the collection of this data already legal is for reasons of substantial public interest. Like when we are in a pandemic situation, there can be we can have access to data that is justified by the public interest that we are now facing. But all these situations need to be addressed on a case-by-case scenario. You cannot just think that we are under a pandemic situation and this would allow you to treat all the data related to the pandemics or to who is infected with COVID or wherever. We need to see if in that particular case, this exception would apply. Nope. And then it comes the first thing that I was talking about that we already talked in here. In terms of clinical trials or clinical studies, you actually have two different informed consents. You have the informed consent for the procedures of the clinical trial or for participating in that clinical trial or in that clinical study. And you also have the informed consent for the collection of personal data. And these two must be individual. You cannot put in the same document the two mixed up. You need, if you are going to do these two informed consents, you need to have one for the clinical trial and another one individualized for the collection of the personal data. And then this will be used as a way to demonstrate that that specific person consent in the processing and in the collection, because it's englobed in the processing of the personal data. And you have to take into account that in terms of personal data and in terms of the clinical study, this person will always have the right to withdraw consent at any time. But as Susanna said earlier, if I remove my consent now, all the treatment that I did before is still under the consent that I gave at that time, okay? And this person will also have the right to access, ratify, asks for the deletion or for a limitation of the consent that that person gave before. So meaning I might give consent today for the treatment or the whole the whole operations that you need to do with my data, but tomorrow I need to have a way to contact, and the easy way to contact the person that is going to be treating the data and saying, I want my data to be deleted. Or I will only allow now you to do this treatment and not that treatment. And it needs to be an easy way to contact, because if there is a procedure that the person can follow to withdraw consent or to limit consent, but this procedure is done in such a way that it will be very, very difficult to exercise these rights, then there is no procedure. Now, in the end, whenever someone collects personal data, we need to define what will happen with this personal data. And in the General Data Protection Regulation, there is no specific time frame for the retention of most of this personal health data. The procedures of the subject that is collecting the data will be the ones that will define for how long this data will be retained. And they will also have to say what happens in the end of the retention. You could, if I'm answered to Bruno now. So if someone asks you to delete the information, can you just anonymize in that moment? If you anonymize this information in this moment, then it would not be personal data anymore. And I would say that you could still use that data because now it's not personal data. Now, there are some regulations, and this now, whoops, sorry, I was trying to. There are some legal diplomas in Portugal that actually establish some time frame for the retention of personal data concerning health. Okay, and since these are established, we need to follow them. For instance, the data related to the prescriptions made by the SNS can only be retained for 5 years. Or for medical records, generally a period of 5 years is also generally considered. But you can have, for instance, the occupational medicine data, meaning, for instance, the data of the workers that are exposed to radiation, to chemical hazards, to biological hazards, can be retained for a period of up to 40 years, okay? Now, once these periods have expired, you can either delete or anonymize this data because it's not considered personal data if you anonymize this data. In terms of clinical studies and clinical trials, this is the scheme. Are you collecting personal data or not? If you are collecting personal data and you cannot anonymize it, then you need an informed consent, but you are also going to need an informed consent just for the collecting of the data that is not anonymized at the time of collection, because it's still personal data. Then if you can anonymize, you don't need anything else. If you can anonymize at the time of collection, it's not personal data, so you don't need anything else, okay? Susanna also talked extensively about the informed consent, so I just did some topics here. You can collect, you will have to have a personal consent, not only for the personal data, but also for the collection of the biological samples, as I told. These need to be very clear one from the other. It doesn't mean that they cannot actually be in the same document, but you can have point 1, informed consent for the collection of personal data, and then point 2, in another separate point, informed consent for the collection of biological samples. You need to specify very well for what are you collecting the personal data, and you cannot really have a generic consent. And it can never be, and this is something that I see a lot in some research institutes, which is even here, which is asking for consent to participate in a study and be informed that your data might be used in future studies. The information that your data might be used in future studies, it's not really an informed consent. The informed consent needs to tell you for what, and for future studies period, it's really not an informed consent. We also have a law in Portugal, Law 12 from 2005, that regulates the creation of genetic databases and biobanks. And you also need an informed consent for the creation of these two types of databases. And the informed consent also needs to be obtained for specific reasons. And this is it. So I think this is a sum up of what we talked about personal data and informed consent. And if you have any doubts relating this, you can always write, and we can always initiate a chat regarding data protection in health and life sciences. Okay, Diana is making, oh, sorry. I just saw that Diana made some questions here in the chat. Let me check them.
I can do it.
So one thing that, so for the ethics committees in terms of clinical studies are defined in the law that governs the clinical studies. It cannot be any ethics committee from an institution that that was not created under the law that creates the ethics committees for clinical studies. You can actually do, for instance, what we have here at the IGC, which is we have some partnerships with some hospitals, and the competent ethics committee of that hospital will analyze our project and be the competent ethics committee for that specific clinical study or clinical trial. Now, can we?
But is there any like Portuguese, like general that you, because it's easy when you have that kind of partnerships and so on with hospitals or when you are working in one, but when you are not in that framework, it's not really easy to.
Yeah, but in that case, I would think that I would say that you need to do some partnership with someone that have a competent ethics committee for the evaluation, or you can actually create one, but it's not so easy.
Yes.
That's why here at the Institute, we actually have the ethics committee of the hospitals that we work with. And the truth is, in most of the cases, we need samples from the hospitals. So the hospital ethics committee needs to be involved.
Yeah, in our case, it's different because we have the data and the material, but we don't have the ethics board.
So how can, so you access the data and the material, so you collect the data and you collect the material?
Yeah, part of my work is on a private laboratory, so we do have the material and
but how do you collect material? The patients or the individuals go to your laboratory to do the collection?
No, they go to, it can come from private practice clinics, from hospitals even, you know, we do not do the sampling ourselves, we collect from.
Yeah, I know, but the thing is, if you are doing the sampling to use in research, you might end up being in under a clinical study, not clinical trial, but clinical study, and clinical studies need to be approved.
Yeah. We are not doing that at the moment, but we are considering to do it.
Okay, my advice is that you would consider start doing it as soon as possible.
Yeah.
We also have that problem here at the Institute, and I think it's very normal for this to happen with research institutes, but my advice is please start collecting your samples under the legal framework that they should be collected.
Yes.
And then you have another question, which is, can we exclude the need for informed consent if we anonymize that? And yes, we can, because no, you don't need an informed consent if the data is anonymous from the beginning, because it's not personal data.
Yes, my question is always like, at first it is not anonymized, but
and then you need personal consent.
Yeah, we always have that, you know, when you draw the cases. But then you can work in, you understand what I mean. At some point you can.
But the thing is, for the general data protection regulation, the very operation of collecting the data, it's already a processing operation. So if you are collecting the data in a form that is not anonymized, you need an informed consent even for that specific step.
Yeah. And do you know that law that I'm speaking about?
Yeah, it's the law
Yeah.
12/2005. It's the one that creates the genetic banks and
Yes.
the biobanks. It's the one that I referred here,
Ah, okay.
and
Yes.
where I went to take out this definitions. You also
Yeah.
need informed consent to create a biobank.
Yeah.
But I know that there are a lot of, so this doesn't mean that it shouldn't be done, but I know that a lot of research institutes don't do it.
Yes, I work with IPO, with the Oncology Institute of
Mhm.
Porto, and there we do all of this because,
Yeah, because it's
we
the
are working with material like, but in the private we work with digitized images, you know, so
Mhm.
it's a bit different. And the information we always get from other labs doing the same, because this is like almost IT work. They are not using informed consent for these types of images. But I do understand that when you collect initially the data, I
But
know.
if you collect an image and you only collect the image, you don't collect anything else, you don't have
Yes.
the name, you don't have the address, nothing else, then it is anonymous.
Yes, that we do that, like when we are researching and speaking with other partners. But when I first get the image, of course, I know, you know, then I know it is.
Yeah. So
On my
then,
side, yes.
okay, so then you can. So you need really, so for that, you would need an informed consent for
Yes.
collection of the data, and also
Yes.
for the informed consent for the usage of those data and that data, because what you are doing is a clinical study.
Yes, yes, I know. We have, this is even more tricky. We have some informed consents because it's the patient have to, from the clients, you know, it's in the contract, but not specific for this.
I would say that if an informed consent is buried in the general clauses of a contract, it's not really an informed consent. And also in terms of if you need, for instance, if you are doing because there are several different types of clinical studies. And if the clinical study is what we call without intervention, which means from the result of that clinical study, the treatment that the patient might be undergoing is not going to change. You can ask the ethics committee that will analyze this clinical study that to forfeit the informed consent. And in that case, you will not need to get the informed consent from the patient.
Yes.
Also, be careful on what you are doing, because in some, this is not related to data, but if you are doing a clinical study with intervention or even a clinical trial, you need to register this thing in Infarmed.
Yeah, no, yes, but that's totally different research. No.
Yeah.
No, but this is kind of a worry now, because all of this digital and AI research, I see this is, we don't have like legal framework yet really well established for this kind of information.
You need to work with the legal framework that we already have, and we have the legal. So there's the general regulation on data protection that will always apply.
Yeah.
And then you have these specific laws that you just mentioned, the 12/2005. There is also the new regulation on clinical trials, which is not so new because it's from 2014. It's just that it's now in effect, and we have the law that governs the clinical studies and clinical trials in Portugal. So all of these legal diplomas need to be compatibilized.
Yes.
Basically this. And it's actually what I like, to be quite honest.
Thank you.
You're welcome. So, Monica, if someone asks for the data to be deleted and you just anonymize the data, this is not, as I said, this is not personal data anymore. So it's, in the end, it's almost, it's equivalent to the deletion. And if you anonymize the data, the previous data that you have doesn't need to be anonymized. So the previous operations that you have done are justified because you have the consent for those previous operations. So if I did the operation A with subject A, and I'm still able to, at this point in time, to go back and know this was subject A, you can keep this because this was authorized at the moment. Going forward, you cannot use the data from this particular subject or the not anonymous data from this particular subject. I don't know if I made myself clear.
Yes, I think so. It's a tricky question because if you have data that you already processed in a not anonymized form, and then you are asked to delete it and you anonymize it, if you go back to the first processing, you can link the data to the individual.
But that first processing, you had the consent to do it. You just cannot use this data anymore in that way.
In that way, okay, thank you.
Okay. Danielle?
Thank you very much again, Ted.
Thank you. It was a
It's been
pleasure.
a very interesting discussion.